Hello, ladies and gentlemen, and thank you for waiting. Welcome to the American Foundation for Equal Rights conference call on the Ninth Circuit Court decision.
Yeah.
All lines have been placed on listen-only mode, and the floor will be open to members of the press for questions following the presentation. Without further ado, it is my pleasure to turn the floor over to your host, President of the Board of Directors for the American Foundation for Equal Rights, Mr. Chad Griffin.
Come here.
Mr. Griffin, the floor is yours.
Where's the stuff?
Thank you so much. Thank you so much, everyone, for joining. I know that many of you were able to watch the live stream of the press conference that we just completed. But on the call today, you have Ted Olson, and I believe I hear David Boies, who's also on the line. And we have also Ted Boutros from the Gibson, Dunn & Crutcher team with us. In addition, the plaintiffs, Chris and Sandy, Paul and Jeff, and their families are here with us today. And it's such a reminder of exactly why we filed this case. Because in California, Proposition 8 took away the right to marry. And today, what the court did affirms that you cannot single out one group of people and deny them the dignity and respect that all citizens deserve. And we are so excited today because of the impact on Chris and Sandy and Paul and Jeff and their families who are with us, but also for all the other gay and lesbian people, particularly the young people, that when Proposition 8 passed, it took away their hope. It took away their hope for the aspiration of marriage that so many Americans, and it's fundamental in our country, it took that hope away. And today, what the Ninth Circuit did was really affirm and to bring back hope for those young people, both here in California and around the country. And we are so thrilled with today's decision. And with that, I will turn it over to Mr. Theodore Olson, who will make brief remarks, and David can make remarks, and then we can open the floor to questions.
Hi, this is Ted Olson. When we started this trial, almost the very, very first words that we spoke when the trial began in San Francisco were these words, that this case is about marriage and equality. It's about the right to marry, and this decision today affirms the importance in American society of the right to marry. The very proponents who opposed us in this case talk about how important marriage was. The difference was that they wanted to keep it to themselves. They wanted to deny this relationship, this institution, this building block of our society, the most fundamental right, according to the Supreme Court, that we have in America. They wanted to deny that right to a large segment of our society because they felt that those persons were unequal or undeserving or different or separate and should be treated differently under the California Constitution. So this case is about marriage, and it's also about freedom and dignity and fairness and decency, how we are going to treat our fellow citizens, our brothers and sisters, our cousins, our neighbors. Are we going to treat them with the same respect and dignity that we ourselves enjoy in this country? The district court earlier and the Ninth Circuit today ringingly reaffirmed the right to equality, the fundamental right to marriage, and the fact that it cannot be denied to citizens on the basis of their sexual orientation or on the basis of sex. This is a very significant milepost on the way to equality in this country. We're not there all the way yet. One of these days soon, I feel strongly that we will be, but this could not be more important. The Federal Appeals Court in the Ninth Circuit covers a substantial part of the United States, bigger than any other appeals court if you count the number of people involved in the Ninth Circuit. So this is a very important decision, and it was 80 pages of tightly reasoned, very thoughtfully articulated Supreme Court analysis of precedents and so forth. So we are one major step forward, and we're very, very grateful to the Ninth Circuit for upholding the right of the citizens in California.
This is David Boies. I agree with everything that Ted has just said. There are days in our nation's history when we make genuine progress towards our constitutional goal of forming a more perfect union. Without question, today is one of those days. Like the day that the Supreme Court decided Loving against Virginia, today the Federal Court of Appeals decides in Perry v. Brown that gay and lesbian citizens are truly equal citizens of this country, and that marriage equality, like other elements of equality, is constitutionally mandated. The court finds that Proposition 8 serves no purpose and has no effect other than to lessen the status and human dignity of gays and lesbians in California and to officially reclassify their relationship and families as inferior to those of opposite-sex couples. The Constitution simply does not allow for that kind of discrimination, and the court relies on the United States Supreme Court's decision in Romer for exactly the proposition that the court uses to decide its case today. This is a giant step forward. This is the first time that a federal appellate court has ever clearly held that marriage equality is constitutionally required. It's not the last step. It's not the last step necessarily, even in this case, because we will possibly have an attempt to take the case to the United States Supreme Court. It's not the last step for marriage equality nationally, because as a technical matter, this case is going to apply to California. The reasoning of the court is much broader, but in order to really establish our goal of complete marriage equality nationally, there is more to be done. But this is a great first step forward, or great giant step forward. It's not the first step. It's a great step forward, and it is one in which I think every American can take a great deal of pride and pleasure in.
Okay. All right, operator, we can open the floor to questions, and again, a reminder: the plaintiffs in the case, along with their families who so eloquently spoke and are the real reason that we brought this case and fought this fight and continue to, are here. So if you have questions for any of the legal team or the plaintiffs, operator, you can open the floor to questions.
Certainly, the floor is now open for questions. If you do have a question, please press the number 7 on your telephone keypad. Questions will be taken in the order they are received. If at any point your question has been answered, you may press 7 again to disable your request. If you are using a speakerphone, we ask that while posing your question, you pick up your handset to provide favorable sound quality. The first question comes from Valerie Richardson of the Washington Times. Valerie?
Hi, thank you for taking my question. I just wanted to ask what the timetable is for couples actually being able to marry in California. In other words, does this decision take effect immediately, or when would you expect, what do you think about in terms of the timetable at this point?
This is Ted Olson. The court stayed the effect of its decision until its mandate issues, which means the other side will be given 14 days to file a petition for rehearing in the Ninth Circuit. If it doesn't do so, the mandate issues 7 days after that. So we're talking about February 28th when the stay would expire. We expect our opponents, the proponents of Proposition 8, to seek a further stay. We will either seek to end the stay if it goes longer in the Ninth Circuit, or to reject the stay if the proponents of Proposition 8 seek a longer stay from the Supreme Court.
The next question comes from Jeffrey Toobin of The New Yorker. Jeffrey?
Hi. I'd just like to pursue the issue of the stay a little further, because I was a little unclear. Is it automatic that the stay goes through the unbanked proceeding, or will some court, either this three judges or some other combination of the Ninth Circuit, have to issue another stay? Because I know you have litigated stays a lot through this case, and I know you're very opposed to them. So wondered if you could just spell out a little more about how the stay litigation will work from here on.
I'll take it, and then David, when I'm done, maybe you fill in. If our opponents seek a rehearing in the Ninth Circuit, during that 14-day period, it automatically extends the stay until a decision on the petition for a rehearing. At that point, we would probably ask that the stay be vacated during that process. If they don't ask for a rehearing petition, then the state will expire, according to page 80 of the opinion, of its own force 7 days after that 14-day period. But I would presume, and I guess you would expect so too, that the proponents will seek a further stay either from the Ninth Circuit or from the United States Supreme Court. The bottom line for us is that constitutional rights cannot wait any longer. It's been a long time since Proposition 8 was passed. Individuals in California are being denied their constitutional rights every single hour of every single day. A district court has upheld those constitutional rights. The Ninth Circuit has affirmed them. It is irreparable injury taking place all of the time, and we don't keep people going to separate drinking fountains or to separate schools forever. We have had enough, and we're going to urge the court to let people get married, as two courts have now held they're entitled to do under the Constitution.
Can I just follow up?
Go ahead.
No. I'm sorry. So the stay will stay in effect automatically while the request for en-banc consideration is pending? I mean, that could be months, right?
The way the court phrases it is that the stay remains in effect pending the issue of the mandate. So it is the issuance of the court's mandate that ends the stay, unless we make a motion and the court ends it earlier. Now, that mandate will not issue during either the time that they have to make a motion for rehearing or during the pendency of that motion for rehearing.
Okay, so that's automatic.
So it's automatic in that sense. So that as long as the mandate hasn't issued, the stay continues in effect unless we ask the court to terminate it. Now, as Ted says, if they try to keep the stay in effect by moving for rehearing, we would be inclined to try to terminate the stay at that point. It's one thing to have a stay until an initial appeal has been decided. Here, the Proposition 8 has been held unconstitutional after a full trial and a very thoughtful opinion by the district court. It has been held unconstitutional by the Federal Court of Appeals, again, in a very detailed, thoughtful opinion. It is now time that if there's a balance to be struck, to strike that balance in favor of permitting people to exercise their constitutional rights and to get married. They've been deprived of those rights too long.
Okay. Next question.
The next question comes from Maura Dolan of the LA Times. Again, if you do have a question, please press the number 7 on your telephone keypad. Maura, go ahead.
Yes, hi. Given how narrow the decision is written, do you think it's less likely that the U.S. Supreme Court would take it? And my other question is, do you expect Protect Marriage to ask for en banc review or to go directly to the U.S. Supreme Court?
David, why don't you take that,
Sure.
and I'll add to it.
Sure. I don't know what they would do, obviously. I think that they probably will try to do something, although I think given how well-reasoned the opinion is and the narrow grounds, the careful grounds of the opinion, I think they might be well just to accept the decision. I think that the grounds for the opinion, in my view, do make it somewhat less likely that the Supreme Court will take it. This is an opinion that by its terms technically just applies to California. We've said from the beginning that California had a number of characteristics that were different from some of the other states, including the fact that California citizens were clearly entitled to marriage equality, and then that right was taken away. I think that the careful grounds and the thoughtful way that the majority opinion goes after this means that the court might not want to try to take this issue on those facts, and might want to wait for a case that raised the more general issue that the court here did not have to face. I think it's also worth, keeping in mind that while the panel here unanimously finds standing, there are a number of Supreme Court decisions that could be read to suggest otherwise, and that is going to be a threshold issue that the Supreme Court would have to grapple with. So I think for all those reasons, the Supreme Court might decide that this was not an appropriate case for it to weigh in on.
I will add with a slightly different take than David. I don't disagree with anything David said, but I would emphasize the fact that while the court put attention on the peculiar facts of California, that an existing constitutional right that had been upheld by the California Supreme Court was taken away by Proposition 8, and that was consistent or similar to what had happened in Colorado when existing rights were taken away from persons on the basis of their sexual orientation. The actual and that allows the Supreme Court to say, well, this is focused on the particular facts of California. In fact, the decision goes vastly farther than that and says how important marriage is to every individual, how inappropriate it is to distinguish between classes of people on the basis of their sexual orientation. I'll just give you one example. On page 77 of the opinion, the Ninth Circuit says, Proposition 8 operates with no apparent purpose but to impose on gays and lesbians, through the public law, a majority's private disapproval of them and their relationships by taking away from them the official designation of marriage with its societally recognized status. Proposition 8 therefore violates the Equal Protection Clause. That language and other pieces of the opinion like that resoundingly reflect the arguments that we were making, that this is a discrimination that takes away a fundamental right and takes away equal protection from our citizens based upon characteristics that they cannot control, that they are born with, or are immutable characteristics. So in that sense, it's a very broad and significant and resounding opinion, and it may be very difficult for the United States Supreme Court to avoid a decision when the voters of California have attempted to take away the constitutional rights of a substantial number of their citizens on an impermissible basis, and two federal courts in California, District Court and the Ninth Circuit, have said flatly that is unconstitutional.
So you mean it may be
I would agree. I would agree exactly with what Ted says. I think that although the majority opinion, I think, following sort of rules of judicial restraint, crafts the actual decision in the terms that are required simply to decide this case, and does not sort of announce a broader decision. The reasoning of the case is reasoning that would clearly support a national right to marriage equality.
And because of that, do you think that might be a reason why the U.S. Supreme Court would take it?
It might be, but It might also be that the court would wait to see what another circuit did with an actual case where the circuit had to face that more general issue. It also is the case that if the proponents of Proposition 8 decide they want to take this to the Supreme Court, they are taking it to the Supreme Court on a set of facts that are perhaps the most difficult set of facts they could have. I mean, this is a case which, as the Ninth Circuit rules, really follows the United States Supreme Court case in Romer, where you had a right, the right was taken away. It was taken away purely on the basis of the status in terms of sexual orientation, and with a precedent like Romer that so squarely fits this court's reasoning, it's not clear to me that this is the kind of case the United States Supreme Court would want to take.
If I could also just remind, I know there are 60 some odd of you on this call representing media organizations in different states, and this was obviously an historic victory for our plaintiffs and for California. It was also a monumental loss for those who oppose marriage equality and have fought so hard and for so long to stop all of our citizens from having equality under the law. And for those states that have gay marriage and have passed similar initiatives to the legislature or so forth, and efforts are underway now to try to revoke those, like have been threatened in New York and a number of other states. There's discussion, obviously, if Washington State moves forward with marriage. And so a reminder to not lose sight of what's happening in other states across the country and what those who have fought so hard to oppose marriage equality have said they will do to reverse those victories around the country. This ruling is obviously tremendous and significant, as Ted and David have put in its light, but I think it's important to remember all of those states where this issue is being advanced and forwarded in the vast majority of cases in a positive way. Next question, operator.
Again, if you do have a question, please press the number 7 on your telephone keypad. We do have a question on the line from Michael Lindenberger of Time Magazine. Michael, go ahead.
Thank you. I just wanted to drill in just a bit on, I guess, the optimism about the reasoning of the case. It seems equally, I guess, legitimate to read the opinion as saying the reason there was no legitimate basis for Prop 8 is because it didn't do the things that gay marriage bans would do in other places. In other words, because of all the guarantees of rights to gay couples in California, Prop 8, narrowly had the impact of taking away only the word marriage, the idea of marriage, and so all these arguments about child rearing, et cetera, were not even addressed. Does that not dampen a little bit of the optimism that this could be a strong opinion, up at the Supreme Court for other cases when they will decide those merits?
Well, this is Ted Boutros. On that point, I think the language would apply. The court spoke very broadly about the fact that the Equal Protection Clause in the Constitution does not permit the public, the majority, to strip away a right of members of a minority group simply because of their status and who they are. That principle comes directly from Romer, from the other Equal Protection Clauses, and I think it would. The result would be the same in any state where the right to marry was taken away from gay men and lesbians. And I think the broader principles, as Ted Olson was making a point, embedded in this opinion, the logic, the rationale will have significant force in these other jurisdictions. The fact that California, that's I think going back to David Boies' point, the reason why this opinion is so difficult to challenge is because the fact pattern is so strong for us that the rights are already there. This is a particularly irrational enactment by the voters because of the way California law exists. but that just makes our arguments extraordinarily strong in this particular case. I think the opinion, logic, and rationale would have big force in other jurisdictions. In addition, it paves the way. In constitutional litigation, this paves the way for other courts to pick up the momentum and to apply this logic and this rationale in all kinds of other contexts.
I know everyone's also still digesting the opinion. It's 128 pages, but on page 5, I'll just read one sentence. Proposition 8 serves no purpose and has no effect other than to lessen the status and human dignity of gays and lesbians in California and to officially reclassify their relationship and families as inferior to those of opposite-sex couples. The Constitution simply does not allow for laws of this sort.
If I could just follow up, though, I mean, that sweeping language, on one hand, supports everything you're saying, but they qualify it by saying the reason why it does nothing more than these impermissible things is because of the fact pattern in California. That fact pattern doesn't exist elsewhere, and other than a handful of other states where they would have to take away these rights, does this not leave open to totally fresh interpretation of what the Supreme Court will do if asked if the federal Constitution guarantees those rights to get married?
This is David. Let me approach it this way. On page 60, the court says, in order to explain how rescinding access to the designation of marriage is rationally related to the state's interest in responsible procreation, proponents would have had to argue that opposite-sex couples were more likely to procreate accidentally or irresponsibly when same-sex couples were allowed access to the designation of marriage. We are aware of no basis on which this argument would even conceivably be plausible. Now, you are completely correct that this is phrased in terms of rescinding access to the designation of marriage. But if you simply substitute it in to that sentence, the circumstances in other states, proponents would have to argue that opposite-sex couples were more likely to procreate accidentally or irresponsibly when same-sex couples were allowed to fill in the blank. I think the following sentence, we are aware of no basis on which this argument would be even conceivably plausible, is still going to be the same. So that while this is a technically narrowly drawn opinion, the reasoning is very broad.
And David, I would add to that point, this is Ted Boutros again, that in addition, we know they had no evidence whatsoever to support any of their claims about the reasons that gay men and lesbians should be banned from marrying. They had no evidence. Their main expert admitted we would be more American the day same-sex marriage was recognized. So here the court didn't even have to go down that road because of the situation in California. But we have a full record that shows that in any state where they try to justify these restrictions, they don't have any evidence whatsoever, and their arguments are completely illogical.
Thank you.
Thanks. Next question, operator.
The next question comes from Peter Schrag of California Progress Report. Peter?
I'd like to follow up on this conversation. If I read the opinion correctly, and I'm not a lawyer, but if Judge Reinhardt's, if I read his opinion correctly, he goes out of his way to say that there is no federal constitutional, or they're not declaring a federal constitutional right to marriage for gays and lesbians where it has not previously existed. That is only a constitutional violation where the right has existed previously, as in California, for 6 months, and that where it has not previously existed, they are not declaring such a constitutional right. Am I correct?
Well, I think that what he says is they don't have to reach that question. That it is enough to decide this case, to decide that you cannot take away such a right from people who have it, and they do not have to decide the question that you articulate. But I think if you look at the reasoning, for example, the reasoning that I just quoted, and you apply that reasoning to a case state where the consistent deprivation of marriage equality has existed, you will find that the reasoning of the court would hold unconstitutional the discrimination in that state as well.
And I will add, this is Ted Olson, I will add this. In the Lawrence versus Texas case, which had to do with the constitutionality of individuals' private sexual behavior, Justice Kennedy said, we're not reaching the issue of relationships and marriage between individuals who might be practicing those types of activities. We're not reaching that in this case. Judges say that all the time. They're not reaching more than what they have to. But the reasoning, as David Boies just pointed out, was pretty compelling. And in fact, it was extremely compelling. And in the dissent, Justice Scalia, who did not like the decision at all, says, well, the majority says this doesn't mean that individuals will have the right to get married and have marital relationships. And then he says, don't you believe it? Now, I will say the same thing here. You read our opponents are going to say, oh, that didn't decide what goes on in Georgia, or that didn't decide what goes on in Arkansas, but we're talking about the fundamental right of individuals to enjoy the relationship of marriage. This decision talks in terms of how important and fundamental that is, and that you can't call it some other name like civil partnerships or domestic partnerships or civil unions and say that it's the same as marriage. Marriage is marriage. The court makes that point very clear, and our opponents made that point, and this court recites the fact that our opponents made the point that marriage is a unique relationship and it's something to be desired by people and can't be taken away from people. And the court in this case also talks about discrimination against a class of individuals based upon their sexual orientation. You put all of those things together, and our opponents might say, oh, we have lived to fight another day. Well, they may fight another day, but they will lose, and this decision will be cited as a basis for that loss.
Next question, operator.
The next question comes from Karen McVeigh of Guardian News. Karen?
Hi there. I think some of the implications have been discussed, but I wanted to ask Chad what the implications were for the rest of America, for the others kind of fighting these, fighting the rights of gay marriage and in different states.
Well, I think for the most part that's been addressed here. I mean, this is an opinion, as I said, that will go down in history. And when I was referring to the other states and the precedent setting that this is, there are a number of other states in the country that have recently passed gay marriage, and there are a number of others that are on the verge of doing so as we speak. And the anti-marriage activists have indicated that in all of those states they're going to work very hard, either through the judiciary or through changing a legislative body or through a ballot measure process. They are going to overturn marriage or revoke domestic partnership or revoke marriage. And so that's what I was referring to when I was talking about the state battles. And I will say something else that this case has done. In the last 3 years that this case has risen, and with Ted and David's leadership, it's allowed us to lift the partisan veil from which this issue has always been discussed and put the spotlight on the plaintiffs and the real-life people who are being impacted every day and their families. And if you look at polling in this country, there are 7 public polls in the last year alone that show the support for marriage equality to be over 50%. So that also goes towards part of your question, which was a political one, the impact that it has in states, and that was 2 ways of answering that question.
The next question comes from Charlotte Robinson about Take Media. Charlotte?
Well, first of all, I want to congratulate you for all your hard work.
Thank you so much.
And what I was wondering is, with today's ruling, do you think that the trial videotapes will now be released?
The court ruled last week that the trial videotapes would remain under seal. As some of you have noted and have followed, our opposition, who's been willing to spend hundreds of millions of dollars, both here in California and around the country, on campaigns, on television advertisements, attempting to articulate why the public should ban gay marriage, once they were in a court of law, under oath, and being examined and cross-examined by Ted Olson, David Boies, and their teams, it had the impact of providing a bit of truth serum. And so what our opposition has done, spent a lot of money, effort, and resources on, is to hide what happened in that courtroom from the American people. Many of you were able to be there, see it, and report on it for yourselves. We will continue to work hard through various means and media and entertainment media to show the world and to show the American public exactly what happened in that courtroom. But for the moment, the courtroom tapes remain under seal because the anti-marriage advocates have worked so hard and objected to their release.
And in the meantime, Chad, would you mention the play 8?
Yeah. So once the opposition fought so hard and successfully blocked the public's ability to see the raw footage of what happened in that courtroom, a number of people, AFER partnering with Broadway Impact, and Dustin Lance Black wrote a brilliant play based on the actual trial transcripts, not made-up words, not imagination, but the actual trial transcripts. And we have done one night in New York on March 3rd. We will be putting on a play in New York that stars
in Los Angeles.
On March 3rd, we'll be putting on the play here in L.A., starring George Clooney and Martin Sheen and a whole list of phenomenal casts playing both the characters on the marriage equality side as well as the anti-marriage side. And so sometimes this is one of those things, be careful what you wish for, because the public just might see more of George Clooney acting out a play than they would 12 days of raw footage. So, like I said,
they may find George Clooney a lot more interesting than just listening to David Boies.
I stopped short of saying that.
I know, but I didn't have to. but I think people ought to ask themselves, why are the opponents of marriage equality so afraid to let the American people see the evidence? This was a trial with examination and cross-examination, witnesses under oath. It went on for nearly 3 weeks. Each side had a fair opportunity to present their case. You have to ask yourselves, why are the opponents of marriage equality so afraid to let the American people see what the evidence is?
With that, we are going to stop today's press conference call, and this entire team will be doing a press conference in San Francisco at 5 o'clock p.m. Pacific Standard Time, and that press conference will also be live streamed at afer.org, afer.org. And if any of you have any follow-up questions, you know how to reach the AFER team press office, so feel free to contact us directly or watch the press conference at 5 p.m. In San Francisco. And I want to thank all of you, many of you who have followed this case since the day it was filed. Today is a tremendous historic day, and we're so appreciative of your attention and coverage of this important issue that does have real-life impact on Americans here in California and across the country. So thank you all very much. Bye-bye.